Welcome to Policy and Politics with me, Tarun Nangia. Our topic today is a special one. How to manage economy with ecology. Case in point is the mining issue in Goa. As we can see today, Goa had two wheels that were running the state. The first wheel was tourism. The second wheel was mining. Tourism, as we all know, collapsed due to Corona, and it seems like for the next 16 quarters, tourism will not be back because the economy is not in good shape. People from all over the world are not traveling as much. So for tourism to be back, it's a bit difficult. Mining has collapsed. Thousands of people are jobless. Thousands of livelihoods have been affected. It's an industry which has been present in Goa for the past 5 decades. Despite of that, we see today that nothing is happening on ground, and the state and its people are starved for running their houses, and the state is starved for paying salaries. So much of problem. How to get out of this mess? And I must say, I'm very happy today to have a stellar panel with me. We've got experience in the executive side, experience on the judicial side, experience in the technical side. I would like to introduce Justice Arjun Kumar Sikri. He's currently the judge of Singapore International Court, but earlier he was the judge, he has served as the judge of the Supreme Court of India. I have with me Aruna Sharma. She has served as Secretary Ministry of Steel and is now on the board of a couple of big corporations, if I may say. We have with us Mr. R.K. Sinha. He has served as Controller General of the Indian Bureau of Mines. I would like to thank each one of you for sparing your time for today's episode of Policy and Politics. We will now start with our round of opening comments. If I may request Justice Sikri to open the episode with his opening comment.
Thank you, Tarun. As you have rightly set the tone by saying that there has to be a balancing between ecology on the one side and the development on the other side. And so many related issues, both on ecology as well as on the development, they do arise, which you have touched by stating that, look, when we talk of economy of a country here, you have discussed about Goa and the income of the state, which is affected, or the employment, etc., and the economic progress of the state of Goa also. On the other hand, when we talk of ecology, that means, or the environment as such, the question that arises is that whether economic activity in the form of mining can be allowed, and if it is to be allowed, to what extent, so that the ecology also doesn't suffer, because the environment at the end of the day is also very, very important. And therefore, we come with what we call, this is a concept which is known in environmental law, is that of sustainable development. That sustainable development signifies that, yes, it recognizes the need for development, economic development, and particularly in a country like ours, which is still a developing country, and it has yet to achieve so many milestones and recover so much of ground insofar as economic progress is concerned. And therefore, the economic activity, which includes mining, also becomes very, very important. And particularly for a state like Goa, which, as you rightly said, was entirely dependent upon the two factors, that is tourism and the mining. Now, that is one side. And the question that arises is, as I said, that sustainable development. What is that sustainable development? If I may say so, just because these are the opening remarks, and then we will develop on that. Two things, if I may say so here. When it comes to, because you said that as far as mining is concerned, it was stopped, it came to halt a couple of years ago, and that was because of the judgment of the Supreme Court, which banned the mining in Goa, in that judgment of Goa Foundation case. Now, the question that arises is that how to balance these two, and in balancing these two, can we totally ignore the other side? A total ban, whether this was proper, or not. We will discuss, as I said, the Goa Foundation case later on. But as far as jurisprudentially is concerned, what I say that a holistic approach is required in such cases, and where the courts are supposed to keep in mind the economic factors as well. And the doctrine of sustainable development is predicated and based on that. And here I call it economic analysis of law. That is, any economic activity, etc., in the legal context, we have to have the economic impact thereof. And how it was done in Goa case, we can discuss on that. But what I am only saying is that this balancing is very much required. And when we talk of balancing, we have to keep in mind a holistic approach, the entire approach here, whether there should have been a banning of the activity which takes away the employment of most of the people in the state, apart from now because of COVID, even tourism has gone. But in the which mining, which was one of the biggest sources, it had generated a lot of employment also. And as you will see in Goa Foundation case itself, Gram Panchayats have come forward to say how the people in the Gram Panchayat, those who are working in those mines, their livelihood is affected. So therefore, that is on the that also is to be taken into consideration. And we have, which I will may develop later on if necessity arises. Whenever this balancing is to be done, we have evolved in last few years judicially. We call it doctrine of proportionality. That means the things should be proportional when we do the balancing.
Okay.
Yes, you limit the mining, that is necessary in the interest of the environment. But then when we talk of balancing, whatever is and in order to serve the legitimate state purpose, environment is a legitimate state purpose. But when whether you could have gone to the extent of totally banning it, and
That's
therefore not maintaining that balance or proportionality. So that these are some of the issues, if I say in the beginning, and
that's
in the context we will discuss this.
That's a very, very important comment made by Justice Sikri. Uh, as usual, he put everything in a perspective which is now easily understandable. If I may say so, one thing I have experienced about Justice Sikri is he puts everything in a simplified tablet form where, we can easily understand everything, which I have experienced over the past 2 years. We'll go to Ma'am Aruna Sharma, and she has served in the secretariat for a long time. That's where policies are made. That's where direction to India is given. The rightful domain or of where the policy direction to India has been given for the past 6-7 decades. Ma'am, give us a policy perspective on this issue of what is there at the secretariat level that you think when you think of a state growing, and what is holistic development as far as Goa is concerned.
You are absolutely right, because many of the solutions lie at the table of policy. Unfortunately, in the case of Goa, the policies have been triggered by Supreme Court judgments. And that's not a very healthy atmosphere, because what Justice Sikri rightly said, if the pendulum is to be balanced, then both have to work together, looking at the holistic perspective. Now, if you take the case of Goa, one member among 5 is dependent on the income of mining. And the whole issue of Goa was not so much of ecology. It was more a solution of the right kind of technology to be flagged, to be ensured, and to be implemented. So, it is not a case that it was doing a harm to environment. In fact, if you look at the case of Goa, it was a set example across the globe where people used to come and see how ecology-friendly, environment-friendly mining can be done. Their problems laid in the way the transportation, that is the logistic arrangement, was being done, where the jetty points and the tippers, they were causing excessive burden to the existing public transport. And for that, the solution was to have a dedicated corridor, not a ban. Similarly, you had this beneficiation plants, because the mining in Goa is very small. It's in acres, less than 100 acres. Whereas rest of the country, it is 100 hectares. So you can compare the two. So that was the case of dumping after the mining. So whether it should be outside the lease area or there should be a dedicated area, and what is the method of disposal. Same for the beneficiation. Same was the problem. If you look at it, it was on power of attorney. So all these solutions were in the policy formulation. And where the stalemate came, it is 100% policy formulation. Because if you go in depth, like today in the Supreme Court, what is pending is what comes first. What is popularly known as the Act, Abolition Act, that has not been decided, and therefore what is applicable to the entire country of Section 8A of the MMDR Act 2015, you say it will not be applicable. So it's like a double whammy for Goa. So if you look at it, the solution lies in policy, in bringing these two acts together and resolving it, not standing at the doorstep of the court and trying to fire the gun from the shoulders of the court. Because that will not go a long way. That will not bring in what Justice Sikri rightly said, to have a balancing act, to have a holistic perspective. And what is most important is that the economy of Goa is dependent on mining. So banning is not the solution. We have to find a solution which will resolve this discrepancy among the two acts, which will resolve that we are eco-friendly. And in fact, the endeavor should be that how do we demonstrate to the world that we are ecologically friendly, yet economically vibrant as far as the Goa mining is concerned. And coming from the steel sector, I will tell you, this is the kind of iron ore which is fit for export. And this kind of a ban, we have lost the market. The market has been taken up by Australia. And now, as and when it revives, it's also going to be a fight to get back your space in the market. So in the sense, you are hitting us from all ends because of this delay in the correct policy resolution, which has to be done on table. And when you do this resolution, policy resolutions, policy making, and look at all these facts, that is where the solution will lie as far as the Goa is concerned. And that is where the main thing is pinching, that nobody is ready to bite the cat. Everybody is looking at each other. The court says that the policy should resolve, and policy happily sits and says, let the court decide, we will follow. So this is not the way we should go ahead as far as the policy making is concerned.
Thank you, ma'am, for giving us a 360-degree holistic perspective on the issue. I also felt the point that you made on India losing foreign exchange. We currently need it desperately, but the economy situation is such that, government is saying Atmanirbhar Bharat, which says that we need to increase our exports. Your point about Australia, which is again a resource superpower taking over our business, is also a point of concern. We'll go across to RK Sinha. The policies made in the Secretariat are implemented at the level of which Mr. RK Sinha has served, where there is a direct action. He gets direct reports from the mines, what is happening, the technical know-how. Could you please share with us, sir, what do you think about this issue?
Thank you, Tarun. So Justice Sikri has already said about the balancing act between the development and the development of the economy and the ecological aspect. So I will confine myself with respect to the mining. What is a sustainable mining? We consider a mining is sustainable once it is a financially viable, then it's a socially responsible, and it is in scientifically, systematically, and environmentally sound practices. So on these three counts, we consider a mines to be a sustainable mining operation. So first of all, it is a financial viability. If the present mining dates back to the year 1951, and from the 1951, it has continued for about 7 decades, where the initial production was only 0.5 million ton. It has gone up to 35, or in 2009 and 10, it picked up to 38 million ton. So naturally, the production has been ramped up. So it can be very well considered this mining was financially viable. Then comes the mining has to be very socially responsible. If you think the Goa mining, they have done quite a tremendous job towards the social upliftment of the villages surrounding the mining areas. In fact, they form MFG, that's a Mining Foundation of Goa, which was a trust or NGO formed by the mine owners, which takes up all the activities and basically lot of social infrastructure development surrounding the mining areas in the villages with respect to supply of drinking water, with respect to health perspective, in education they have been done. Even they have gone beyond their normal affair to build the bridges and roads as per the requirements of the state government. So social as well as infrastructure development has been done to a greater extent and commendable way. Then comes scientific, systematic and environmentally sound practices. As Arna ma'am has already said, Goa Mines has shown the way to the world also, or to the India in the other parts, because it has been systematically and scientifically developed after carrying out adequate exploration. Even they have taken adequate measures towards the protection of environment with respect to ambient air quality, noise level, water quality. With respect to post-mining reclamations, some of the mines have done wonderful job. Even the mined out area has been leveled and a football ground has been made over there. Even pisciculture has been developed. Some of the well laid out gardens have been developed over the mined out area. So all these three counts, we can very well say that Goa mining has been a sustainable is so long. But basically the problem is now coming from the legal side, because the leases were granted in perpetuity by the erstwhile Portuguese government in as per mining colonial laws 1906, when the Goa became a part of Union of India in the year 1961. So from 63, actually, the MMDR Act was implemented. And then all these problems came. Then Abolition Act is there. Abolition Act 1987, which said all the mining concessions will turn to the mining leases. And now the Abolition Act has been challenged by the concessionaires, and it's pending before the Honorable Supreme Court. So as Arna ma'am has already said, it's a whether we have to take it head on, either with the bureaucracy or with the judiciary, but we have to find out a solution, and the solution definitely lies within the existing framework also, provided all these organs of the governments comes to one table. This is will be my submission.
Thank you so much, Mr. Sinha, for sharing your free and frank views on the subject. Uh, I'll go across to Justice Sikri at this point. And sir, I would want to know from you, mining generally was going on under deemed extension pending renewal application. But as far as Goa's case is concerned, that was in a sense not held true for Goa. Could you give us a perspective? Why could that be a reason, and should it be rethought?
Actually, let me tell you, Mr. Sinha has, in a way, answered this question. But yeah, in that perspective, I like to, when you have asked me, I like to put it in that perspective. What has happened in this case of Goa, it's a actually comedy of errors, if I may say so. And the tragic situation which has arisen because of the political position which Goa was enjoying when it was under Portuguese rule. Now, as Mr. Sinha rightly pointed out, the concessions used to be given by the Portuguese government to the miners at that time, and which were for indefinite period. So therefore, when Goa became independent in that sense and became the part of Union of India, and at that time the miners were having, by virtue of the grant which was granted to given to them by the Portuguese government, the mining leases which were for eternity with no period prescribed. Of course, in 1961, then when MMRD Act was extended to Goa, then the Goa also became, in a way, bound by the provisions of that act. And here, this kind of war which started. by this Abolition Act and MMRD Act and then Section 8A, etc. All this, if you see the history, it has been happening as to uh, according to MMRD Act, then when the leases period they are truncated and they are specified, then the question this was challenged initially by the miners and saying that look, the leases which are granted earlier, they should continue to be governed by that. Of course, this was rejected, but then, as I said, Abolition Act came, which Mr. Sinha has pointed out, and then again another legal war which erupted. In the whole process, when it was going on, and when you see in 2014, I think Justice Patnaik and Justice Nijjar, they passed an interim order also when panchayats went to them. And this was, to some extent, although it was an interim order, but balanced order, saying that the mining should be allowed in the meantime on the basis of the licenses which they have. We will consider these aspects, whether these are for 50 years, and 50 years will start from when. This is another issue which have started, whether they will start from 1961 when the MMRD Act was, or Abolition Act, whether they will start from 1980 something or so. Because if it is 86 or so, then it goes up to 3036. Otherwise, 2021. So in all these issues, Section 8A is given a backseat, which is applicable in other states. So therefore, what happened, and I again say what Aruna ji and Mr. Sinha has said, that had there been an approach, even on judicial side, taking into consideration all these aspects and not piecemeal approach, and ignoring other aspects, probably solution would have been found. And if it has to be on judicial side, and if all come, as Mr. Sinha said, on the table here, if it is in the court, they can't come on table as such. But yes, all this can be projected to the court, and the court should be, made to realize this, and so that the court takes into consideration all these aspects and decides it for once for all. Everything should be decided, not that some things are pending, etc., like as the Abolition Act and when you have said that. So this is because of these reasons peculiar to state of Goa that this state of affairs we are landed today. And what I would only say that even in when the judgment was passed and said that the concession, it should be now the latest judgment that which prevails today. Fortunately, matter has again come to the court again, and the court can again give a relook into the entire issue as a whole. But what is argued on behalf of Goa Foundation, one or two hearings which have taken place, and when I have followed that Goa Foundation is still taking a view that their lawyer that look, it is all now stand decided and it should not be reopened. The other side is saying that look, no, all those issues still remain to be decided. So therefore, they should be decided. So what I feel is that here now the judicial approach should be a combination of what Arunaji said, a policy to be left to the government. Government should come out with that policy, tell and show it to the court that look, this is how we want to take care of the entire problem, and this is the solution, holistic solution. And law is very clear that policy is the domain or forte of the executive, and if the policy is otherwise sound and it meets the test of judicial review, then court has to normally accept that, because the law is that the court cannot, we are not the policy maker judges, and we cannot substitute our wisdom to that of the executive, because the executive knows it better. They have gone into this by taking expert advice, etc., and therefore that should be accepted. Yes, there are certain circumstances in which judicial review is permissible, but if it uh, passes that muster, then that would not be a problem. So therefore, what I feel is Supreme Court has got an opportunity now. It should take a holistic, as you rightly said, 360 view of the matter, and in the whole process, the balancing act which is to be done, and the proportionality test. After all, the we have, on the other hand, at stake two major things, two or three. One is resources of the state, economic resources, income, etc. Other is social problem, that is unemployment, which is generated because of this. And third is foreign earning of the foreign exchange, foreign because there was a time, as Arunaji has said, that it is not taken over by Australia, where there was such a demand of iron ore from Goa in other countries, particularly in China, if I am correct, and there were huge exports to these countries. And but after this is totally banned, then all this has come to standstill.
That's
So these are
that's a
very important factors which have to be taken into consideration.
Um, I like the sort of clarity that Justice Sikri brings about to any issue that I have read in his opinions as judgments as well recently and some from some time back. This is what I like. Totally explained, one, two, three, four, all points are clear and one understands where one has to go. Uh, Thank you so much, sir, for sharing it so lucidly with us. Ma'am, I want to know from you, what do you think on the comments made by Justice Sikri? He spoke about policymakers' view, and also one small question to add after that uh, would be because the specific abolition act for Goa, that also has led to problems. Do you think it's true?
You are absolutely right, and I thank Justice Sikri for such clarity and putting out clearly the role what one expects from judiciary. Yes, all policy have to start the scrutiny that we are abiding by the constitution and by the law. But law making is definitely the part of the executive. Policy making is part of the executive, and they can't escape from that. You know, that is very important. So if you look at it from the point of view of the Goa, the entire problem in Goa mining is a creative or self-creation. So we have become a problem creator than problem solver. So between the judiciary and the executive, we have created a problem, and then now saying, oh, it is entangled. Now what do we do about it? So that entanglement has to be removed by the right policy making. And Abolition Act is very clear. It is like bringing Goa into the forte of the nationalistic perspective so that the same law applies to everyone. So it is not something like an hindrance. It is sort of amalgamating Goa towards India. But that amalgamation should not create a problem for a state which had a very high per capita income compared to Indian standards. And now we have brought it to among the lowest because of these default in the correct policy or timely policy making. The Abolition Act, what you correctly said, needs to be resolved from this point of view. It very clearly says that when it came on 23rd May 1987, 50 years from that date, as per MMDR Act 8A6, very clearly says that lease granted prior to the year 2015 shall be deemed to have been granted for 50 years. So even if we forget the Portuguese history, we forget everything, the Abolition Act 1987, 50 years, it is legible. After 50 years, you want to subject it to auction, you want to subject it to any other methodology of renewal, absolutely all right. Disrupting a complete no-no is not the answer. And even though now the matter is at the table of the Supreme Court, the postponement of dates is going to cause a lot of problem. This is the right time. If we are able to resolve it now, post rainy season, the mining operation can start off. So we hardly have a month with us, that is the month of September. October onwards, we have to enter back in the market, we have to enter back. You know, it stands to the credit of the miners that they are still paying the salaries of their employees. But how long they can sustain? The balloon is going to burst someday, and that is going to cause a lot of agony in that area for no fault of theirs. The fault lies somewhere else. And if you look at the case that has been filed, ecologically, there is no substantial evidence that has been produced. And like I said before, the 3-4 issues what they have, the answer is there. There is a technological answer, there is a methodological answer, there is an answer of how we do the logistics arrangements. So we do have an answer across the globe. And across the globe, mining is there. It is not that the mining is bad, that mining is bad, the mining is harmful for ecology. No, answer does not lie there. And let me tell you that, and Mr. Sinha can substantiate it, as long as iron ore is there, besides grass, nothing can grow on it. The moment you remove the iron ore and reclaim the soil, you will get a thick forest. So this basic understanding has to be very clearly in the minds of the people. If you want grasslands, be happy with it and let the iron idle there. But if you want a thick green ecology, you have to remove that iron, use it for the economical development, and have a greenery as we move ahead into the story. So yes, there is a problem. The Abolition Act and the MMDR Act, it is very important to harmonize the two. And that harmonization is possible. It is not that it is not possible. If you go through the legal sections of it, the answer lies there. Only thing is you have to highlight that answer, you have to underline the answer, and what Justice Sikri rightly said, tell the court that this is where the answer lies, this is where the policy making is going. These are the precautionary steps which will be guided for the protection of ecology, and this is how we plan to go ahead with mining in Goa. This kind of a clarity, half a page note is more than enough. But that half a page note has to come. We can't keep on waiting for somebody to draft it. It has to be drafted, it has to be executed, because otherwise we are losing a good, healthy, economically vibrant state. And like we are talking about this COVID impact, that's something which locks down. Don't expect that it will regenerate itself to pre-levels. Many will be a complete washout. They may not regenerate themselves at all. They'll get aborted. The seedling will get burst. So that is very, very important.
That's a very fair.
You are right. We can't allow that to happen to Goa.
That's well explained. And one thing I like about Aruna Sharma ma'am specifically is that with the kind of frankness that she speaks about judiciary, she also speaks about the secretariat and policymakers with that absolute frankness, which is one good quality about her that I see and like. Mr. R.K. Sinha, a quick comment from you before we close. We're almost out of time.
So just I will substantiate to Justice Sikri and Ma'am Sharma, because the solution lies within the existing framework. Now the government of Goa has already filed a review petition in the Honorable Supreme Court, but again the government of India has said that there will be a conflict of rights unless the Abolition Act, challenge to the Abolition Act is decided. Again, it brings the problem to the table of the court. So if the court goes ahead and calls all the 2 or 3 organs and then decide the issue in a holistic manner, that will only resolve it. Otherwise, it will go on unending problem. Unending issue will remain alive, and it will be very difficult to see Goa resumes mining operation in near future. So these are I think it is in the hands of now court only to call all the conflicting parties or the petitioners, and they ask to sit on a table in whatever manner justice says, and then decide the issue. Because Abolition Act, there is a one appointed date is there, which says that it will be applicable from 20th December 1961. That requires a change, because Bombay High Court has already held it cannot be applied retrospectively, it has to be applied prospectively. So if you take from 1987 and then with the MMDR Amendment Act 2015, any lease granted prior to 2015 will consider for 50 years. It will give an opportunity for the existing mining concessions up to 2037. So that will resolve all the issues actually. And then after 37, you go for the auction of the leases.
If I may say so at the end, that this is a fit case for economic approach or economic analysis of law approach, which I also said in Shakti sugar mill case. Yes. And where there are 2 principles: rational choice theory, which is to be applied. That means choice of individual and society to maximize their individual satisfaction, and social efficiency theory. I think this case is the classical case which invites both the theories, and if these are kept in mind, solution is not far to see.
Thank you so much, all of you. Thank you, Justice Sikri, Ma'am Aruna Sharma, Mr. R.K. Sinha, for sparing your time for today's episode of Policy and Politics. I hope the policy makers and the decision makers watch you and take sensible approach towards the whole issue. Thank you so much. We'll revisit this issue soon enough when things are in better shape. Thank you so much for joining on Policy and Politics.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.